women's anything.
But like you said, anyone can identify whatever they want, you call them whatever you want, but that's not a meeting of the mind. Let's say, for instance, my objectionable reality is obviously determined by what I witness, what I see with my own eyes. So, for instance, if a guy's got a what is a bloke, if a woman's got a what, it's a woman. It's as simple as that. In any other mammalian species, we don't have this issue except for human beings who've got retarded brains.
I agree with you.
My argument is no one has the right to compel my speech and call them a she when they're a he. And if I call them a he and I'm accused of being transphobic, then fine, I'll wear your label. I'm transphobic then. I don't know. Call me what you want.
Then they make it legislation.
Then
they make it legislation.
Well, we'll get on to legislation.
Yes.
Shut up and let him get on with his blinking talk.
That's it.
Most of what you're talking about is going round and round and round. Let him do his job. That's what he's come here for.
Yeah.
We disagree, that's why we're voicing our opinion.
Right. So breach of
Right, you have
peace.
to impose on
Yeah,
me.
so
Who do you think you are?
Yeah.
What is right? What is a breach of peace lawfully defined as? Okay, because the Justice of Peace Act 1361 says we are all entitled to the peace. So this problem's actually been resolved 700 years ago. So a breach of peace is basically was summarised in the case law in 1982. Okay, and this is what it is according to law. So before a person breaches another's peace, they must have the evidence to support the lawfulness of their belief that they have a right to breach another's peace. So if they haven't got evidence which shows harm was actually done or likely to be done, now likely to be done is did that person follow their due diligence? Did they apply a reasonable person's knowledge to a person or their property? That's it. Okay? And if you don't have that evidence, you have no lawful right to breach another's peace. So just very quickly looking at this, okay? And if you, with the trans thing, have no evidence that I've done what? Actually harmed you or was likely to harm you. Up yours.
The case was quite a low level though. It's something about disturbed. If you disturb another person, like
No, it comes down to the knowledge. Do you have evidence?
yeah.
Okay.
But the related to harm, but the harm is very low level, like if you've disturbed someone else, and that's probably where this plan stuff's all coming in. Because
Explain, because I've not come across this
I'm
disturbing.
sure when I read that I was alarmed at how low level.
It is a low level because nobody has a right to impose their will on another.
Yeah, so
It is a very, very low level.
so the evidence is that you've disturbed someone else.
So show me the harm.
Well,
They're
my
disturbed.
feelings, I'm
They're
harmed.
disturbed.
That's your own choice. How have I disturbed? Okay.
I'd have to look at
Yeah.
the. I'll look at.
Okay. But basically, it's simple. Nobody can impose their will on another. If you make the claim as trans that I'm hurting your feelings, okay, you are imposing your will on me. Therefore, you have claimed, therefore you must prove. So prove to me how I've hurt your feelings. Okay? Because feelings, I decide what my feelings are, not somebody else. Therefore, if I'm the one that decides how I feel, okay, how can somebody else have harmed me? It's an impossibility. Okay? So, it's ridiculous. But it's he who claims. Now, the Commissioner of Police of the Metropolis versus Razi, okay, again affirms all are equal under the law, nobody's above the law, and it reaffirms the breach of peace. Even a policeman needs to evaluate the evidence before they act. So what's happening nowadays is the court phones up and says, oh, so-and-so, we've got a disturbance here. All right? So if there's a disturbance there, the police should come down, evaluate the evidence of the two parties. Do they do that? No. Therefore, they're acting unlawfully. Because they must apply their mind to the evidence, which means they need to gather all the evidence and weigh up, based upon the evidence, their action. So the first thing is to investigate, to get the evidence. Okay? And that there, as you'll see, comes to determining the parties' respective duties, rights and obligations to one another. That's the first thing that needs to be established. And then the other thing about the breach of peace, what they've been trying to do is collective punishment and premature. So what that case established was that if one person here, okay, has done something, there is no right to impose on everybody. You can only impose on that person. So this particular case was about some protesters going down somewhere. They were on a bus, but it wasn't only protesters, but they impounded the will on the whole busload of people. Okay? Again, they had no evidence of any harm having been caused. They believed, oh yes, it's likely, but that didn't pass the threshold. Okay? And is it proportionate that just because there's one bad apple, I punish everybody? Utter nonsense. So even just with this basic knowledge, how on earth was any of this COVID stuff possible? It just is totally lawless. So that is what breach of peace is all about. So that's the foundation. All are equal under the law. Nobody's above the law. We're all entitled to the peace. We have an obligation that we do not breach another's peace, i.e. we apply the best available knowledge, and when we see somebody else breaching the peace, if we do not intervene, then we are breaching the peace by not correcting it. I.e., we need to stop turning a blind eye. Because we have an obligation. By turning a blind eye, we actually are breaching the peace. Okay? So it's about us accepting responsibility of our obligations to one another.
Can you give your definition of breach of the peace? Like the peace?
Quite simply, if somebody is stopping another going about their life with the knowledge, or their knowledge, and my best available knowledge, that they're not causing harm.
It stems from wartime, peacetime, doesn't it?
No, breach of peace goes back to the family.
Because
Two kids.
the R versus Hal, when you read what it was about, the R versus Hal was they were having a party. It was allowed.
Oh yeah.
People were pissed off.
That is the specific facts, correct?
Yeah, so
that's
they
the
came and
specific
they
facts.
said he was breaching the neighbour's peace because they were
Correct,
making a noise.
correct. However, what R versus Hal did was went through the case history and summarised the whole history of breach of peace into one ruling.
Yeah.
And the specific facts of the case were what you say, but the principles were derived from the knowledge of history of case law, summarised into one judgment. Okay? So it doesn't really...
Yeah, because sometimes the police arrest, for instance, for making a noise, or public disturbance, for instance, they arrest for that as a breach of the peace, which is incorrect. That's an incorrect interpretation of what a breach of the peace is.
Well, it might or might not be, because it depends on a normal, what is reasonable. So basically, is it reasonable here to have a party with the music blaring at full blast, okay, at 2 o'clock in the morning, as opposed to in a row of terraced houses, one of them blasting at full blast, which is disturbing everybody else. So reasonable depends on the facts of the case. So, that there's a distinguishing thing. is it fair and reasonable, okay, when people go out and have a drink on the weekend and make noise and go around drunk, is that the same as if somebody does that, you know, at 10 o'clock in the morning on a weekday? You know, you've got two totally different sets of circumstances or facts. Okay, therefore, it's very case specific, but it's the principles that are important.
I'm trying to make sense of it because, in terms of like automatic facial recognition, I get upset by that, and you're saying I get. It's about infringement on someone's rights, isn't it?
Correct. Okay. Again, a right is in law called a chose. Okay. That covers either a right which you have to either property or anything else. Okay? So, if you have a right to something, so I have the right to freedom of speech. If somebody imposes on that right, they need to show me lawful excuse. Okay?
You're not phased by that wouldn't phase you. You don't. So, for instance, again, substance and form, it doesn't bother you because ultimately you know who you are and what you are.
No, it all starts from within. You need to know
So if
yourself.
they film your face and they send you a notice, it doesn't really make a difference because, you know, who cares if they recognise you, they don't recognise
Yeah,
you.
what
Bottom
the-
line is,
May
you can
I?
still stand up and hold yourself in court.
The right to privacy is where people feel about it.
Could I introduce a definition of a fundamental human right, which I came across not so long ago? Which
Yeah, yours was quite good.
it's really good
Yeah, just
to me because whenever I apply it,
express it so
Yeah.
that people can.
so a fundamental human right are those rights which all individuals can claim simultaneously,
Yeah.
all together, without forcing anyone else to cater to their needs.
Okay, and hence you have the right to create your own shelter from the environment, air, water, food, freedom of association, freedom of speech.
That resolves your claim to speak though, then, doesn't it, Hugh?
Can you say that again, please, Hugh?
So what is key to this is simultaneously claim. All individual can simultaneously claim
Yeah.
without forcing others to look after their needs.
Thank you.
Okay, now natural justice. We've looked at gravity, and now I want to just introduce equity. I've already said that the courts run a fraud on people, and the fraud is they tell you we are not courts of conscience, i.e. morality, we are courts of law. Utter bullshit. This was settled in 1615. Okay, natural law goes like this. I follow my conscience which dictates to me what's right or wrong. And if nobody opposes me, I carry on with that right. That's natural law. So, what does that mean? If somebody turns a blind eye or doesn't stand on their rights, they have none. So, natural law continues. Those who stand on the right, i.e., we're putting an opposing force, harms no one. Okay? So, this thing about natural law, when people talk about natural law and, you know, why don't we get it? Because it's up to you to claim, up to you to stand up. Okay? Because until people change their belief system and understand the responsibility, if I witness somebody else being harmed, I have an obligation to stop that person being harmed. Okay? So it's about understanding our responsibility and obligations to one another. We need to stop turning a blind eye. So far we've always basically pussyfooted around from it. And in Liverpool, outside the station, I've watched people. There's a homeless person here. People will walk, they will cross the road, they will walk, and they will come back like this. Okay? That is absolving responsibility. That is knowingly causing harm. Okay? we need to find the knowledge to address these things. So if you don't have the knowledge, you are not knowingly causing harm. However, by having a closed mind, you are, because a closed mind is a matter of choice. So it's important that people do it.
Sorry, Mark, did you say that was established in 1360?
15,
1350?
yeah, 1650.
1650.
Okay?
Sorry, what was that? What was
The
that?
Earl of Oxford case.
Oh, right.
Right. Now, basically, common law precedent means that a lower court must follow a higher court's decision. So when people talk about jurisdiction, and we'll look at it, jurisdiction, there's no such thing as common law jurisdiction. Okay? There's no such thing as equitable jurisdiction. Jurisdiction we'll talk about later, but basically, if you don't understand how the system works, okay, you're going to get an injustice. If you ask the wrong questions, you'll get the wrong answer. So basically, in the magistrates' courts, every court is bound by a higher court's decision. In 1615, the King decreed, because you had the courts of common plea on one side that gave a judgment to party A, and you had the chancery courts which gave an opposite judgment to party B, i.e. we had a conflict now. The two different courts in the land came up with two different answers based upon the operating mode. A decision had to be made. And guess what? The conscience won. So what it said was, the courts of equity, as they were at the time, the chancery, was based on equity. What is fair and just prevails over the common law, which is basically what the court of common pleas was, okay, in the event of conflict. I.e., if a common law judgment is not fair and just, because equity is about what is fair and just. So if there's a conflict, if something doesn't feel right, the rules of equity prevail over the existing common law judgment. And that is what is called lawful excuse. So you're arguing lawful excuse from an existing common law precedent using the rules of equity, what is right and wrong. Okay? So that goes back to 1615. And therefore this nonsense that courts are not courts of morality, sorry, my conscience tells me what's right and wrong. Therefore all courts are courts of conscience, i.e. all courts are courts of morality. Okay? And so what happens is, to force the court to listen, okay, you need to have the knowledge to put the court in a corner and say, you have no choice but this is what you must do and this is why you must do it. Okay? So basically when you are in a magistrate's court, quite simply, in any court, because of common law precedent, you just simply say, in accordance with the Earl of Oxford case, the rules of equity prevail over the common law, and what he's saying is utter nonsense because it goes against the conscience. It's unconscionable. Equity is invoked by anything which feels wrong. Okay? So, now, why is there this confusion with legislation and law? Here's an example of why. The Senior Courts Act 1981. What has happened there is, what they've said is, in the senior courts, so that there is the Crown Court, High Court and Appeal Court, they have legislatively codified the common law, the Earl of Oxford case. And so basically what they're saying is legislatively, it's a legal obligation of the senior courts to use the rules of equity in every matter which is before it. However, they haven't legislated the common law into the county court nor the magistrates' court. Okay? So you can't rely on the Senior Courts Act if you're in the county court or the magistrates' court. Why? Because that's where they screw the people over. Over 95% of cases are settled actually in the magistrates' court. Once we force them to use equity, it starts to stop. Okay? So what is equity? So equity prevails, the rules of equity prevail over the common law in the event of conflict. So equity is what is fair and just as dictated by our conscience. And that's the guide as to what is right and wrong. Equity is invoked when anything goes against the conscience. I.e., if something does not appear fair and just, boom, equity kicks in. Equity acts in person, i.e., it's people, will not suffer a wrong without a remedy. Oh, sorry, let's just quickly look at equity acts in person. Okay? Are we all familiar with fictions of law, straw man, all of that sort of stuff?
Yeah.
Yeah. Okay. Would society be able to exist without fictions of law? Hmm?
That's a big one.
That's a good question.
Yes.
I think it would.
How?
Yeah,
I don't understand how it's possible.
Yeah, how?
Corporations are fictions,
Yeah.
Yeah.
or corporations couldn't, they need.
Okay. What's your name?
What's yours? No, sorry.
What's your name?
Hugh.
There you go. Fiction of law, straw man. You.
It's not a fiction.
It is a fiction of law.
Of law. It's just
Yeah.
one way of distinguishing one person from another.
And for that we need fictions of law.
Yeah. But you're back to contract there again and consent.
Agreed.
I've been given the name Hugh,
Agreed.
and
I absolutely agree with you. The
Yeah.
point that I'm making is, if we did not distinguish, so that if I say, Hugh, can you stand up, please? Okay?
that's a
Who's
fiction
going to
of law.
stand up?
Yeah.
That's
That's
a
a,
fiction of law. Your telephone book on your mobiles,
yeah. Agreed.
fiction of law. You don't remember numbers and associate it with a physical being. Okay, you do that via a name, a fiction of law. Society could not exist without fictions of law.
Yeah.
Okay? So, however, equity is about the substance of that fiction of law. So, a corporation, so the definition of a person, okay, is a major, major issue that people have, spend energy on. And the Interpretations Act 1978 defines a person as singular or plural, incorporated or unincorporated. That's the definition of a person. So, what is an incorporated person or group of people? I.e., one or more of us that act under a fiction of law. So, an unincorporated individual is what? A natural person. An incorporated individual is a fiction of law. So the definition of person includes natural people as well as fictions of law. So wherever in an Act of Parliament you read the word person, that's how it's defined. It can be the living man or woman, or it can be the living man or woman acting as a corporate entity. Okay? So, all of these people saying, oh, I'm not a person, because the legislation says person. Okay? Equity is about substance. What is substance? So, an example of substance is, was your mind in control of your body, which was in control of the thing, which was traveling at that speed, at that place, at that time? Okay? Whether you're a man or a woman, I'm sorry, a little kid can tell the difference. Well, I suppose now with trans it's maybe a bit more complex. Whether you were driving, what other words do people use? Traveling, whatever other words people want to use, okay, is irrelevant, because your mind was in control of your body, which was in control of the thing which was doing driving or traveling or whatever you would call it. Okay? Whether it was a car, a conveyance, God knows what, okay, makes no difference. The thing, that's the substance.
So Mark,
Yeah.
where it says equity acts on the person.
Yeah.
So the person can be incorporated.
Or corporated. Yeah. Okay. So basically, this was one of the things with Calvin's case, right at the beginning, on the 4th. What the Ministry of Justice was saying was, okay, we, the Ministry of Justice, are the principal of Her Majesty's Courts and Tribunal Service, who are the principal of the magistrates. That was their claim as to why they have lawful right to represent the person. So what we said was, quite simply, gee wow, we've got no problem with the Ministry of Justice. We have no problem with the Her Majesty's Courts and Tribunals. In fact, we have no problem even with the Magistrates' Court rules. But when somebody is not following that and acting outside of that, they're on personal liability as a free agent. Okay? So that was the simple argument, and basically it goes like this. It comes from mid-1800s, Lord Kearns, in respect of directors of companies, i.e. an incorporated body. So the substance is what we'll talk about. But if we first talk about the thing. A company cannot act for it has no being. It acts through its offices. And where those offices, where the company is liable, a company cannot act, it acts through its offices. Where those offices act with authority of the company is liable. Where they act outside of it, they're on personal liability. So the substance is, a company is a fiction of law. Therefore, the equity, the substance behind that judgment says, in any fiction of law, governments, court, any fiction of law, the same principle applies. As long as an officer is acting within the authority of the principle, they cannot be held personally liable. But guess what? No fiction of law can act. Therefore, by impossibility, a fiction of law cannot do anything. It has no being. And therefore, it can't do anything unlawful. So guess what? All unlawful actions are in person. All right? That's how simple it is.
Say that again. Yeah.
Right. A fiction of law, okay, it's fiction.
Right.
Therefore, by impossibility, it can't do anything. It has no being.
Piece of paper.
Yeah. Okay.
Piece of paper, it's whatever. It's an
Concept.
idea, a concept.
Right.
Okay? So, because it can't act, it can't do anything wrong. It can't even do anything right either. Okay? So, it acts through the living people who are agents of the fiction of law. Principle is the fiction of law, and the agent is the living person. So, because the company can't act, it can't do anything unlawful. Therefore, by impossibility, when something's unlawful, it must be the actor themselves that are liable for the unlawful action. Okay?
Yeah.
So from the CEO down, they're the ones liable, basically.
Well, even the CEO.
Yeah, that's what I'm saying, from the CEO down, they're all liable.
Every person, because a company can't do anything. It's
Yeah.
fiction. It's impossible for it to do anything. It can only be the actors, the people, that can be held to account. But they've made this legal nonsense, legalese nonsense, that, oh God, we can just hold anybody to lie. Okay, equity knows no time. What that means is, when I know how to seek remedy for a wrong, I can go back and get that remedy. Hence, this statute of limitations nonsense is precisely that, nonsense. Okay? They threaten you, within 21 days you must put in an appeal. Otherwise, forget it. Okay? The rules of equity prevail, therefore once I'm with the knowledge, then whether it's 42 days, 5 years, 10 years, 20 years, when I know how to get remedy, I will get remedy, and I have the right to remedy under the rules of equity. And those who want equity must do equity. Okay? So, what is equity in essence? Equity summed up is honour, which means my word is my bond, I walk my talk. Good faith is I don't put my self-interest above that of anybody else. And clean hands is I do everything honestly, openly, transparently, no hidden agendas, no nothing. What does that sound like to you?
Beautiful.
Hmm?
Beautiful.
So simple.
Yeah.
And guess what that describes? A meeting of the minds and consenting by my free will to the duties, rights and obligations. Contract.
Contract.
Everything is contract.
Yeah.
Okay? So,
Where people are quoting 7 principles for transparency with people not giving their names, clean hands is if they're refusing to give their full names, that's the way they're not providing full transparency. So
correct.
that's
Yeah.
the way to put it to them.
Yeah.
They're not acting with clean hands.
Okay? So basically, in 1762, oops, sorry. 1762, Lord Mansfield came up with this. Okay? What he said was, no man shall set up their inequity as a defense or a cause of action. So if I've done a wrong, I cannot turn that into a right. If I've done a wrong, I cannot bring a claim resulting from that. Okay? So, what gets me is, we've talked about Earl of Oxford case 1615, this year 1762. Why have we still got this shite going on out there? This has all been settled.
Was it Lord who?
Lord Mansfield. Okay? And then that natural justice prevails. Okay? Again, basically, any decision given without regard to the principles of natural justice is void. Although there exists no clear definition of the principles of natural justice, it cannot be said for this reason it does not exist. There's an unbroken line of authority to the effect an officer cannot lawfully be dismissed without first telling him what is alleged against him and hearing his defense of explanation, i.e. the due process of law is what's being described here. Okay? So, what is the due process of law? In the same judgment, the right to be heard by an unbiased tribunal, the right to have notice of the charges, and the right to be to answer to that defense. And the law is really simple. Okay? Now, this case here is 2021. This was in Scotland. The church was bitching and moaning that they had to close because of COVID regulations. So what happened here, in this case, again, they went through the history and put it into one case. And their conclusion was, for something to have the force of law, okay, it needs a bloody good reason, a legitimate aim. All reasonable options must be considered, and the one that is most proportionate must be the chosen option. Okay? So, what does proportionate mean? It's defined as the one which least impacts another's basic rights. So, with this, there's such a simple test now for anything. Okay? COVID regulations, for speeding fines, for anything you like. Okay? Before Parliament can impose its will, it must meet those 3 tests. Any act of Parliament, if it doesn't, that's it. It's irrational.
What was that case?
What is that?